Hello, you're watching Addleshaw Goddard's Employment Channel on the 4th of August 2011. In today's programme we'll look at a Supreme Court case ruling which confirms that contract terms can be set aside to reveal the true agreement of the parties. We'll also look at an appeal decision where an employee was dismissed fairly for making a mistake, even where the mistake had no major consequences. And finally, with just under a year to go, we'll look at the new ACAS guidance on how to best manage employees during the Olympics. Last week, the Supreme Court has ruled that car valeters whose contracts expressly described them as self-employed and allowed them to provide substitutes were actually working under contracts of employment. Employers should be aware of this case and understand its consequences, as it's a stark reminder that in every case the true agreement of the parties is key, and express terms that don't reflect that true agreement should be disregarded. Claire Benson comments on the facts of this case and what this means for employers.
In the AutoCleanse case, there were 20 claimants who were car valeters engaged on contracts which expressly referred to them being self-employed, and they were responsible for paying their own tax and national insurance. They complained that they hadn't been paid the national minimum wage or received paid leave under the working time regulations. To succeed in those claims, they had to demonstrate that they were workers and not genuinely self-employed. The tribunal ruled that the claimants were in fact employees, notwithstanding the express provisions of their contracts. Following appeals to the Employment Appeal Tribunal and Court of Appeal, the Supreme Court has now upheld the tribunal's decision. The Supreme Court ruled that it was right for the tribunal to have disregarded the contract terms, as these didn't reflect the true agreement of the parties. To set aside contract terms, there's no need to show that the terms were a sham or intended to mislead. It's enough to show that the written terms do not represent the intentions or expectations of the parties. This decision provides important confirmation that, in the employment context at least, express contract terms are not always king. They are, of course, very important, but it's the reality of the relationship that's key. Contracts that do not reflect the reality can't override the true agreement of the parties and will simply be set aside. No amount of clever drafting can overcome that, and so it's certainly something for employers to bear in mind, particularly if they have a policy of labelling individuals as self-employed in contracts where this actually may not be the case.
Thanks, Claire. Next up, we have the Employment Appeal decision in Wincanton and Atkinson and another. A sensible decision confirming that employees can be dismissed fairly for making mistakes, even if the mistakes do not have major consequences. In this case, 2 lorry drivers worked for a large supply chain and haulage company, and both men held HGV licences. But in 2009, their employer discovered that their licences had expired. So they were driving illegally and their insurance was potentially void. Both men were dismissed for gross misconduct. The employees then brought unfair and wrongful dismissal claims. The tribunal upheld their claims because, although the consequences could have been horrific, ultimately they were hypothetical and the company hadn't suffered at all. It said that allowing the licences to expire was a grave error by the claimants, but an innocent one, so dismissal was unreasonable in the circumstances. The employer appealed and its appeal was upheld. The appeal tribunal found that although there were no serious consequences when the licences expired, the mistake could have endangered the future of the company and the livelihoods of all of its employees. It wasn't the scope of the actual consequences that mattered, but the potential for major repercussions. A dismissal therefore fell within the range of reasonable responses and wasn't unfair. A word of advice for employers from Claire Benson.
This decision will come as a relief to many employers, as the original tribunal's finding implied that employers couldn't dismiss employees for negligent acts that had no consequences. To minimise the risk of such claims, employers should make it clear in contracts and staff handbooks that acting negligently or contrary to company or statutory regulations can lead to summary dismissal. And where employment duties depend on holding valid licences or other documents, it's a good idea to remind employees on a regular basis of the need to check licences whilst reiterating the consequences for expired documents. Employers should also make sure they treat their employees consistently when invoking disciplinary procedures. In this case, the employer was able to convince the tribunal that they were justified in not dismissing a number of employees in the past for letting their licences expire, as the circumstances were different to this case. but in many other cases, employers often won't be so fortunate.
Thanks, Claire. With just less than a year to go until the Olympics, ACAS have issued some guidance on getting the best from staff and avoiding absences during the Olympics. New and updated guidance, including how to best deal with the 70,000 employees who volunteered to work at the Olympics, will be published in the coming months, and we'll keep you updated as and when this guidance is available. A copy of the initial guidance can be accessed by clicking on the link below the screen. And as the countdown to the Games continues, ACAS is urging employers to start talking to employees about their plans and consider having a simple policy of first come, first served for booking leave. The guidance also talks about the importance of clear communication and guidelines, the need to consider flexible working arrangements, how to deal with performance issues, for example, problems around staff watching lengthy coverage on their computers, and also understanding the legal rights of volunteers and how volunteering can help a business. If you'd like specific advice on this, please do not hesitate to contact your usual Addleshaw Goddard contact or by clicking on the Contact Us box to the right of the screen. We're also keen to hear your views and experiences about how your organisation is planning to manage these employees during the Olympics. And if you've faced particular issues in the past, perhaps with the usual HR headache that a major football tournament brings, or you know of an approach that works well and that you're happy to share, please do let us know. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.